Hello, welcome everyone. We're going to give folks just a moment to join. So now's the perfect time. If you don't have a coffee, get one real quick, get comfortable and settle in because we've got a lot to cover today. And I promise we will make it worth your while. For those of you I haven't had the pleasure of meeting yet, I'm Kim. I'm the Director of Account Management here at HR Covered, and I'm absolutely thrilled to be co-hosting today's session with some truly amazing employment lawyers, Tom and Ljubica. If there's ever a curveball in Canadian employment law, they've not only seen it, handled it, they've probably already answered 100 questions about it before you even get there. To all of our amazing clients, welcome back. It's always so great to see you. If this is your first time with us, here's a really quick intro. HRC Law works with organizations of all sizes in Canada with risk mitigation, legal compliance, and proactive guidance. They help you navigate complex employment law issues, protect businesses from potential lawsuits, and ultimately they're here to save you both time and money. Today, they're going to be going over a 2024 review for employment law. I know there's been quite a few significant changes this past year, and let's face it, staying on top of it all while running your organization is no easy feat. So today, what they've done is they're breaking it all down. What's changed? What does that mean for you? And how can you stay ahead of the curve for 2025? Before we dive in, just a couple of quick housekeeping notes. This webinar is being recorded. We're going to send it out to you afterwards. You can rewatch it, or you can share it with someone else who you think would benefit from it. We're going to wrap up with a live question and answer. So please feel free to drop your questions in the chat as we go. I know this is always everybody's favorite part, and we're going to try to get to as many questions as we can. So on that note, I'm going to pass it over to Tom and Ljubica.
Thanks very much, Kim. Thanks for the introduction, and it's great to be with you all today. I'm Tom Archibald, and with my colleague Ljubica Durlovska, and we are with HRC Law, which is a law firm that is related to HR Covered, and we work with a lot of the same clients and help employers tackle difficult problems. So just before I get started on my part of the presentation, I'll just give a quick overview of the two of us, and of course give our standard disclaimer at the beginning of all presentations that none of this is really intended as actual legal advice related to any particular situation that you may have. It's more intended in the nature of general legal information. So it's a high-level overview, but certainly for specific legal advice or any particular employee problems that you may have, certainly reach out and contact us, and we can look for ways to assist you further. So moving on, a little bit about me. I'm an employment lawyer with HRC Law. I've been doing this for about 15 years. Also got some business law experience. But like we do here at HRC Law, we advise and assist employers with all kinds of employment-related problems, from terminations to accommodations, absenteeism, investigations, etc. And there's my contact information below. And then my colleague, Ljubica, also an employment lawyer, practicing for 10 years, and also does essentially much of the same work, dealing with the whole spectrum of employment law issues, from hiring to firing, human rights issues, investigations, and advising on all kinds of ESA compliance issues, including sales of businesses and so forth. So she too can be reached at HRC Law at the contact information below. So with that in mind, I'll just dive into my part of the presentation. I'm going to go over just some of the highlights from some statutory legislative changes, and that means laws enacted by legislatures or the parliament, if it's the federal government, or regulatory changes. So that's sort of the statute part of it, and Ljubica after me is going to talk a bit more about the court judge-made law, the common law, some of the case law developments that are equally important in the realm of employment law as we move forward. So I'll be touching upon a few different jurisdictions, but I'll start, of course, with the federal jurisdiction. Our favorite level of government in Canada, of course, the federal government. And of course, there's been some changes in 2024 that some of you may already have encountered, and I'll just touch on them briefly. The main one was the change to the mandatory notice periods on termination. In February of 2024, they moved from the old system of just 2 weeks notice for anybody that's had more than 3 months of continuous service, but now they brought it in line with the model in all the 10 provinces, which is 1 year per year of service up until 8 years maximum. So that brings it into line, essentially, the termination notice provisions that are found in most provinces, including Ontario. Also was a statement of benefits requirement. An employer is now required to provide a basic summary of certain key information to an employee upon termination, such as right to vacation benefits, wages, severance pay, and any other benefits and entitlements that they may have. So those are some of the key CLC requirements. There were also some other reforms aimed at, and this is a theme that sort of runs through some of these legislative developments, is an attempt to address the technological changes that have arisen so quickly in the modern workplace. And so some of these changes, legislative reforms that we're going to talk about briefly, try to reach out and capture some work called gig economy work, or work in non-traditional places, such as through online platforms. And so some of the reforms that took place in 2024 involved extending employment law out to those kinds of work, as well as sort of acknowledging that the modern workplace, even a standard formal workplace, now has remote work as a constant feature of it, potential feature of it, and tries to regulate that as well. So under the federal jurisdiction, the approach has been essentially to not really address gig workers per se, or freelance workers per se, but rather to address the independent contractor employee distinction, and making some amendments to the Canada Labour Code that essentially presume that any person who is paid remuneration from an employer is now deemed to be their employee. And there's a prohibition now, a specific one, against treating an employee as if they were an independent contractor, misclassifications. There's already been risks and of course potential penalties that go along with misclassification, but this now actually makes it even more risky to misclassify an independent contractor as an employee, or vice versa. And so some of those reforms are intended to protect gig workers who are often characterized as independent contractors. So that's the federal level. Now moving to the provinces, starting with Ontario, of course, the biggest province, there's been a series of couple of major legislative amendments. The first one was Bill 149, and this just introduced a couple of minor housekeeping amendments relating to how an employer has to pay tips and gratuities to their employees. It specifies the methods that has to happen with. There's also some new requirements for job postings. Employers will be required to disclose if they use artificial intelligence to assess candidates. Employers will be required to include information about expected compensation, which is actually a big change for job postings, where you don't often see specific compensation levels. Employers, interestingly, will also now be prohibited from requiring that employees have prior Canadian work experience. And then finally, employers will now have to retain copies of advertisements for up to 3 years. So there's just some new requirements on the front end of hiring. There's also a minor requirement that actually came up and created a little bit of confusion earlier in the year relating to vacation pay. And the simple amendment was that, as it stands now, if an employer and employee want to agree that vacation pay will be paid on every payroll or every quarter or every month or something, that now has to be enshrined in a written agreement. And essentially that was the sum and substance of that reform. And I think it got misinterpreted to mean that employees were entitled to somehow be paid out vacation pay, but that's not the case with that particular amendment. There's also some new prohibitions on deductions from employees' wages in some common scenarios involving restaurants, gas stations, or any other establishment where a customer has purchased something and then leaves without paying. Now, an employer is specifically prohibited from deducting any of those losses from the wages of the employee who happened to be on staff at the time. So that's Bill 149. Moving to Bill 190, Working for Workers 5 Act. I believe there's now 6 and 7 have been enacted since then, but Working for Workers 5 included a couple of other important amendments, one relating to sick notes. as many of you have experienced, when an employee is away for a medical reason, over time, you will want to get some kind of third-party confirmation of their medical condition, usually from their primary care physician. This actually now prohibits you from asking an employee for a certificate, a so-called sick note, in order for them to qualify for sick leave under the ESA. And that's just the 3-day sick leave. So that doesn't necessarily apply to leaves beyond that. So that's kind of an important new change. However, employers can still ask employees to provide information that is reasonable in the circumstances. So that may include their own description of the medical condition, but it just excludes the requirement of an actual note. Couple of other administrative changes to touch on briefly. The penalties, maximum penalties and fines under the ESA for noncompliance don't arise too often. There's not often a lot of prosecutions under the ESA, but if there are, then maximum penalty is now doubled to $100,000, which can be on top of any order to pay to an employee as well. So that's worth taking into account. For job postings, there are also some further amendments relating to the transparency and the information that has to be given to candidates who are interviewed. And essentially, the statute said that only prescribed information has to be given to candidates who are interviewed. And thankfully, so far, the only thing that's been prescribed that an employer has to give is whether a hiring decision has been made or not. So thankfully, there's not a list of things that you have to tell every candidate that you employ or interview for a job just yet. But that could change with regulation. Also in Ontario, and this touches back to the digital work, remote work, gig work economy kind of amendments that took place this year, Ontario has expanded the definition of work to include work done at a private residence, which is where a lot of remote work occurs. And that's an amendment to the Occupational Health and Safety Act. So it now extends the protections of the OHSA out to the circumstance of remote workers, which is a increasingly common and very prevalent mode of working of employment today. Also, interestingly, it expands the definition of workplace harassment to include harassment that takes place through a medium just like this, a video call. So that brings the law up to date into the modern reality that many, if not most, meetings today do take place on digital platforms. And so there's no reason to exclude them from the coverage of the protections of the OHSA relating to harassment. Ontario also had come into force some reforms similarly, and I won't dwell on these too much, relating also to gig work economy. These were first enacted in 2022, but first started coming into force in 2024, and then some this year as well. Essentially, the model in Ontario is different than that in the federal and British Columbia, which we'll see shortly. And in Ontario, they don't define gig workers, so-called digital platform workers, as employees, but rather what they do is define who they are, and they're defined as anybody who takes the provision of payment for rideshare, delivery, courier, or other prescribed services. So it's relatively narrowly confined. But those workers within that definition are given a series of rights that are kind of similar, but not identical to the rights that employees have. There's a minimum wage. There's the right to a recurring pay period. There's prohibitions against withholding and deducting from wages of digital platform workers. So these are essentially workers who are delivering food, Uber drivers, Lyft drivers, essentially, and other similar type companies. So I won't go through all the other amendments, but essentially it was a sort of a code of rights almost for digital platform workers that just came into force in Ontario. And so if you're involved in that line of work, you certainly would want to educate yourself about those. So that's Ontario. Just moving to the province of Alberta, not a whole lot of legislative change other than some change to bring a little bit more perceived fairness to how tips and gratuities are collected in service establishments. They codify a lot of the principles that were already the law, but are now enshrined as statutory provisions, so they provide a bit more comfort to the employees. They codify that tips and gratuities are the property of the employee, for example. They allow employees to enter a tip pooling agreement. They restrict the ability of the employer to join into such an agreement. And I won't go into all the details on that, but if you're in the restaurant or hotel business and your employees, have some of their income from gratuities, this would be a worthwhile amendment to pay attention to. Employers will be prohibited from treating tips as part of the employee's wages, withholding any tips, deducting, etc. And any kind of breach of those could actually lead to a complaint to the Provincial Ministry of Enforcement for the ESC. So that's the legislative changes for 2024 in Alberta. And then just touching briefly on BC, as I mentioned before, BC also, like the federal government, has attempted to regulate digital online platform workers through the approach of actually saying they are employees, and therefore the entire act, they'll be treated the same as all other employees. They don't set up a separate code of rights like Ontario does. They actually create a definition of online platform worker, and they deem those workers to be employees with all the same rights that other employees in British Columbia have. So they define an online platform worker who accepts through an online platform, picking up and delivering an online order, or transporting passengers whose transportation is ordered through a ride-hail online platform. So I think we're pretty familiar with those workers. And again, these legislative reforms are meant to capture them and attempt to bring them under the umbrella of regulation that all other employees are subject to. There's minimum wage rights, job security, and so forth. I won't bore you with all the other details of all the minutia of the regulation, but those are the major strides that have been taken to try and bring employment law up to speed with how work is performed more and more in the digital and kind of digital nomadic economy, almost the way that people can work from almost anywhere, and the way to actually communicate and get collaborative team projects done through digital platforms. That the commonality of that experience is now reflected in the law. So that's the legislative piece of it. And I will now turn it over to Ljubica, who is going to talk about some really interesting case law developments from the courts coming from Ontario and other places. Thanks very
Fantastic.
much.
Thank you, Tom, for that really good review of the legislative changes. And thank you, Kim, for the intro. That was great. For my part, I'm going to talk to you about the top employment law cases in 2024. Full disclosure, it started off as a list of 10 plus, and it had to come down. There was no way we could cover everything. So I've pared it down to maybe 6 or 7 cases, and I'm going to try and get through them fast because I'm mindful of the time, and I know there's already lots of questions in the Q&A. So I'll just get right to it. Let me figure out how to go to next. Here we go. Okay, so we're going to start off with human rights and with the case of Aguele versus Family Options, Inc. This is an Ontario Human Rights Tribunal case, the HRTO. And this was a discrimination claim by an employee who alleged that her employer failed to accommodate her childcare needs by not providing her requested shift changes. And her requested shift changes were due to difficulties obtaining childcare, and the employer attempted to accommodate the preferences, the shift preferences, within their operational constraints. So, for example, when shifts were available that she could take, they were offered to her, but otherwise they weren't. This was like a rehabilitation type of center. The shifts had to be pretty specific, and so the shifts they were offering maybe didn't coincide 100% with what Miss Aguele wanted. And she kind of dug in her heels, and she wasn't going to move. She wanted the shifts that she wanted, and she was unwilling to accept the proposed shifts. In the end, Miss Aguele quit and claimed that she was constructively dismissed and that there was discrimination based on family status. At the HRTO, it was found that no discrimination existed since the employer did their best to accommodate, but the employee was uncooperative. The HRTO emphasized that accommodation is meant to be a collaborative process requiring cooperation from both parties, not just one side. But the employee in this case was unwilling to accept the employer's proposed accommodations, which were reasonable in the circumstances. So I think she was offered, she said that she could only work from 3 to 9 p.m. And she was offered shifts that were within that range, but not exactly what she wanted, but she just didn't end up getting those shifts. And so ultimately, the employer wasn't obligated to create new shifts or to split existing shifts just to accommodate this employee. So this case is great. It confirms that an employer's duty to accommodate is a two-way street. Employees are not entitled to their preferred or their perfect accommodation, but the accommodation that is reasonable in the circumstances, having regard to the employer's business needs and the client base. So we're going to jump from there to consideration and two-step offers. And I know lots of our clients, Tom was probably going to be nodding, lots of our clients do these two-step offers. And it's a big no from us, but you'll see in this case a lesson, an expensive lesson learned. So this is Adams and Thinkific Labs. This is out of British Columbia Supreme Court. The employer had sent the prospective employee an initial email offer of employment. And I'm going to give you dates just for reference. So this is August 19th. She sent an email offer of employment, and Thinkific in that same email says to her that she's going to be asked to sign an official employment agreement once she's provided her full legal name and her preferred start date. The offer email didn't include things like termination clause, restrictive covenants. It only contained sort of what her pay was, her benefits, any additional perks of the job. So the employee accepts this offer on August 20th, so the next day in the morning. And then in the afternoon, Thinkific sends the formal written employment agreement, which we're going to refer to as the letter agreement. That's what they refer to it as. And in the letter agreement, there are new terms, including termination, non-competes, and other clauses that are protective of the employer and not really beneficial to the employee. Thinkific didn't offer Ms. Adams any additional consideration in exchange for signing this later agreement, the letter agreement. Ms. Adams signs the letter agreement without issue. She doesn't say anything about it. She begins working, but she's terminated less than 2 years later. At issue here was whether the second, more formal contract was valid, since Ms. Adams knew she had to sign something different before starting, or if it was invalid since she signed the second, more restrictive document without additional consideration. And the court in this case ruled that the letter agreement, that second, more formal agreement, was not valid. And it described the offer as having, the initial offer as having painted a picture that was nothing short of glowing and positive. And then on the other hand, they described the tone and impression of the subsequent letter agreement as being one of, we told you all about the good stuff, but now that you're on board and you've signed, here are some additional terms that we're imposing on you. So as a result, the court found that the initial offer and acceptance was a complete agreement between the parties. The letter agreement was unenforceable due to a lack of consideration, and the employee's entitlement to severance was determined by common law principles. Based on the circumstances, the court awarded her 5 months of pay in lieu of notice with her short 2-year term. So this case is a reminder for employers to avoid two-step offers at all costs. Employers should provide potential employees with one concise written document that includes all of their employment terms, including termination. So when you know you have the right candidate, take the time to complete a full offer, an offer of employment, whatever you call that document, a contract, an employment agreement, but make sure it's fulsome, it protects you, and it is in exchange for them starting work. So anytime you are going to give an employee, either an existing employee or a new employee who's already received something, a written contract, you need to provide consideration to make sure that it is going to be valid. Okay, we're jumping now from consideration to workplace investigations. This is going to be all over the place, but it's worthwhile. It's good. So this is Metrolinx and Amalgamated Transit Union. This is out of Ontario as well. In this case, 5 male employees of Metrolinx were dismissed for a private WhatsApp chat amongst the group in which they had made some negative, derogatory, and sexist remarks about a female coworker. The chat happened to be sent to the coworker and was actually only uncovered amidst a completely separate investigation, nothing to do with that chat. The female co-worker was then asked by Metrolinx to submit a formal complaint and to participate in an investigation. But she failed to file, or she refused rather to file a complaint or cooperate in the investigation, stating that she just was stressed and didn't want to deal with it, which is all too common in our experience. After termination, the 5 male employees appealed their decision to an arbitrator, and the arbitrator at first instance found that the employer could not conduct a fair and impartial investigation without the female co-worker's input. They also found that the WhatsApp messages couldn't constitute harassment because the conversations took place outside the workplace and on the employee's own time and weren't available to the public generally. Metrolinx disagreed. They appealed to the divisional court, and the divisional court ultimately held that the arbitrator's decision was unreasonable. And particularly, they found the arbitrator's conclusion that the issue should have been dropped when the female co-worker declined to file a complaint or to participate in the investigation was incorrect, as it contradicts the employer's legal duty to investigate workplace harassment even when no complaint is filed. The court also criticized the arbitrators focusing too much on the employee's privacy rights, stating that the conduct, regardless of its origin, became a workplace issue once it involved the workplace. So once it was about a co-worker, and once that was brought into the workplace, the employer essentially wasn't permitted to stick their head in the sand and pretend it didn't exist. They had a duty to investigate and A and B to protect their other workers. So this decision shows that even seemingly private conversations that make their way into the workplace, and I know lots of our participants have probably seen that. All of these private conversations that make their way into the workplace can and do become disciplinable workplace issues if the contents are relevant to the workplace. All right, jumping again to fixed term agreements. Again, I know lots of our clients and lots of people on the other end here are going to know about fixed term agreements. In this case, of Copel and Lissani Homes out of Ontario again. Ms. Copel was hired by Lissani Homes on a 1-year fixed term contract, and that included termination clauses for both cause and without cause. And I guess this employee just wasn't working out. 6 months after she was hired, she was terminated, and she was provided with 4 weeks' salary. Ms. Copel sued Lissani for wrongful termination, and she was looking for a higher payout based on her original termination date in her fixed term contract. She argued that the termination clauses were void for contravening the ESA, the Employment Standards Act, and she claimed entitlement to her salary for the unexpired portion of the contract term, which was an additional 6 months. The trial judge agreed and awarded her 6 months of pay. The employer, Lissani Homes, disagreed. They appealed, arguing that if the termination provisions of the agreement were invalid, then so too was the termination date set by the fixed term contract. And just by way of background, just to explain this, whenever there's an invalidity in one part of a termination section in a contract, all other termination provisions in that contract are infected. It's like a virus, and all of them become invalid. So what the employer is saying is, if you can't just pick and choose which parts become invalid, if this part of the termination section is invalid, then that means that the fixed term end date is also invalid because it forms part of the termination agreement with the employee. The Ontario Court of Appeal disagreed with the employer. They found that the invalidity of the termination clauses did not affect the validity of the fixed term clause. The fixed term clause wasn't considered a termination clause, and it remained in effect despite having invalid termination clauses. And so the appeal was dismissed. So in this case, even when an employment contract contains an invalid termination clause, a fixed term clause in that same contract will remain in effect and require the employer to pay compensation to the employee that would have otherwise been earned up to the end of the fixed term. And this is really why we 9 times out of 10 will not recommend having fixed term agreements, because the liability could just be too great. If you have a 2-year fixed term and an employee who's not working out 6 months later and you're looking to terminate, you might be on the hook to pay them 18 months. Versus if you have an indefinite term contract, then you would be in a position to pay much less, potentially. All right, jumping again to, this isn't too much of a stretch. This also has to do with valid termination provisions or invalid termination provisions. Here we see 2 cases at each end of the spectrum. We saw everything in 2024. We got Birch versus Data Stealth Inc. on the one hand with valid termination provisions, and we have Dufault or Dufault, however you want to say it, versus Ignace Township on the other hand, where there was invalid termination provisions. And I did put the wording of the termination provisions of each up on the slide. I know it's probably small, it's probably too much. I'll see about sending this to everybody so that you have it, but you can, it gives you an idea about the kinds of wording that are going to be considered and the level of detail that judges go into looking at these contracts. So in Birch, in a very rare victory for employers, I say rare because it is notoriously hard to draft a valid termination provision, especially in Ontario, where the where it is, there's a different standard for cause termination, so it's really hard to get there. But in Birch, the Ontario Superior Court upheld this termination clause on the left in the employee's contract that said that they would be, their termination entitlements would be limited to the Employment Standards Act minimums. So the clause was unambiguous and it clearly removed the employee's common law entitlements. If you dig a little deeper in there, you'll see it talked about outstanding wages, vacation pay, minimum entitlements to notice of termination or pay in lieu of notice, severance pay, and benefit continuation, all which are part of what the Employment Standards Act requires for without cause terminations. And then in the second paragraph there, it definitively removes the employee's right for common law termination entitlements. And then in Dufault, on the right-hand side, the Ontario Court of Appeal dismissed an appeal by an employer who at trial lost a wrongful termination case, and they lost it with this wording here. If you dig a little deeper, again, they tried to define cause as being for willful misconduct and neglect, but also something else. That first point there tries to define it as something else. It's too small on my screen. It's hard for me to see it. I think it's upon the failure of the employee to perform services as herein before specified without written approval. So they tried to define cause in some way that is not permitted by the Employment Standards Act. You have to be mindful, the Employment Standards Act is very specific on this. It says that you can only terminate an employee without notice or pay in lieu of notice for willful misconduct, disobedience, or willful neglect of duty that is not trivial and is not condoned by the employer. So you have to check off all of those requirements to be able to terminate an employee without paying them anything or giving them notice. But importantly, so that's kind of settled law. That was one of the findings, but really important in this case was the 3 words there, at any time. So the court said, an employer can't terminate an employee at any time because the Employment Standards Act clearly has, there are times when an employer is not permitted to terminate an employee, including when the employee is on a job protected leave of absence. So if that's the case and the employer can't terminate at any time, then this language is offside. So 3 tiny little words have invalidated the town of Ignace termination clause for this employee and probably every other employee that they had on their roster. So this decision serves as a really good reminder of the importance of drafting employment agreements carefully and diligently, and to seek legal advice when it's appropriate. Employers should be, okay, and we're going to move into this. Employers should be looking at their templates, looking at their contracts, not just once every 5 years. I think that used to be the recommendation from employment lawyers. Now it's not even once every year. It's every time you're going to give a contract, you should really be consulting with somebody, because if you had a contract with the at any time language prior to this case, you had a valid contract and you had no issues. Post Dufo, you don't have a valid termination provision, and the contract needs to be updated, right? So drafting carefully is really important, and really getting some advice if you need it. So everyone out there should be going into their employment agreements right now and checking out the language if you can. No two-step contracts, just as Adams and Thinkific showed us. If you're going to be providing a contract to an employee when they're starting, it should just be a one-step process. Here's the contract that you will be working under. Here are your terms and benefits, but also the terms that are going to benefit us, the employer. Fixed term contracts, again, 9 out of 10 times we are going to say, no, don't do it because there's a lot of liability there. And then investigating properly is going to be really important. And this might have to happen even if there is no formal complaint. And I would venture to say that if anyone who's a manager and above has any knowledge that there is a health and safety concern, so like harassment, violence, discrimination, then it should be investigated. Whether or not there's a formal complaint really shouldn't matter. And with that, I think we're going to move on to questions. And I see lots of questions here, so I'm sure we'll be able to get to most of those, hopefully.
Excellent. Well, thank you so much, Ljubica, Tom. That was some great information, and I'm sure a lot of food for thought for people. I bet everybody right now is trying to pull up contracts and see if those 3 little words are on them, right? I do see there's a lot of questions, and we're going to get to those. And I know why there's questions. This stuff is not easy. It's changing all the time, and that's why HRC Law is here. We are unique in offering an unlimited subscription. I know Ljubica said reaching out to an employer every time you hire, that that can really add up quickly, and we do things a little bit different here so that you're always protected and supported without having to worry about how much you're spending every time you pick up the phone. So we've never done this before in a webinar, but kind of excited for this. We're actually going to offer you a chance to try them out. So we are offering some specialized subscriptions for a limited time. It's going to give you 30% off for the rest of 2025. The limited time being April. So if you're watching a recording of this, just watch. If it's past April 30th, 2025, you may be too late for this. But please, if you do want to take advantage or get more information or anything like that, send us an email, service@hrcovered.com. In the subject line, put webinar 30. That's the code to get that discount for that special program. If you completely forget the code and you're not taking any notes, just put in the subject line, Kim, I forgot the code. I got you. Well, I'll be watching. But again, service@hrcovered.com, webinar 30. And I am going to start getting into some questions now. Okay, first question here. What is at stake if I misclassify an employee as a contractor?
Okay, I can start, I guess, with that one. Definitely a lot at stake. It's a very risky endeavor, to put it bluntly. Whenever you consider doing that, you need to look at the total context of the relationship, and sort of focus in on the 4 factors, the test for control, and looking at the test for whether the factors that a judge looks at to determine whether someone's an employee or an independent contractor. And as we discussed earlier, the Canada Labor Code now actually has specific penalties for misclassification. But on top of those, you can have potential repercussions for claims for unpaid vacation pay, unpaid wages, unpaid overtime. So that would involve the employee going to the Employment Standards Branch and saying, I was always an employee, not a contractor, and I'm owed A, B, and C, and D. But a equally important risk is the Canada Revenue Agency, the tax implications. If CRA believes that you misclassified, they can levy penalties, they can levy reassessments and go after withholdings that were not withheld. And as we all know, it can make your life kind of difficult, to say the least. So yeah, major repercussions. And so it's always good to consult with a lawyer or HR consultant to get their view on whether what you're proposing has some possibility of being upheld as a contractor relationship, because it's a combination of the written document, but also all the different ways the work is done and paid for. Sorry about the long answer.
That's okay. Long answers are good answers.
It's okay.
You're getting all the information in
Yeah.
there. All right. So next question here. Do I need a written agreement to deduct extra payments made in error to an employee from their next pay?
I can field that one. Normally, no. Short answer, no. If it's an error, like an accounting error or some other error, administrative error, but my definition of error and your definition of error might be different. And I see this quite often where they say, well, it was an error to do that. But was it an administrative error? Like, was $1,000 just added to the employee's pay without anything else? Or was that for something and now you consider that to be an error? If that's the case, then you do need a written agreement, right? So what is defined as an administrative error is very narrow. And so you have to really dig down into what it is that you think was the error or is the error, and whether or not you can deduct from an employee's pay.
Okay, excellent. Next question here. This is a good one. Wage deductions. If you can expand a little bit, does it cover or how does it impact things like employee uniforms or tools that are not returned?
Yeah, good question. And this comes up a lot, with if you have a contractor who has equipment and supplies, ladders and jackets and boots and so forth. Employees will often have equipment in their custody, sometimes vehicles as well. But you do need to have a written part of your contract. Doesn't need to be a separate contract, but in order for there to be an authorized deduction, there's some specific rules under the ESA for that, and I won't bore you with all the details, but generally speaking, there are you can do deductions for things like equipment, things that are given to them in the course of their duties, etc. There are certain things that you cannot make an agreement even if they agree to it. Things like, for example, it's losses. If a customer claims the business suffers losses because of something the employee did, you can't have the employee claim certain kinds of damages. So there's some narrow limits on that, but generally speaking, if you have it in your employment contract that the employer may deduct and you have it worded right, and a lawyer can help you with that for sure, you can make those deductions at the end of employment or at any other point in time, so that you can make it without having to chase them down. You can actually offset it from anything that you owe them, but you have to be really, really careful, absolutely, in crafting those agreements.
Okay, excellent. And I'm seeing a couple questions here. Is this webinar being recorded? Absolutely, yes. We will send it to you. Share it with anyone that you think will help them as well. Okay, next question. Are we required to accommodate an employee that indicated they can only work from 8 to 4 due to medical reasons?
I'll take that one. Without further specifics, I can't really say, because we have to think about what are the operational requirements of the employer themselves. We have to think about what reason is behind this 8 to 4 requirement. Is it a medical reason? Is there a functional abilities form or some other medical form that says this is a requirement and it has to be between 8 and 4? Is it because of appointments? Maybe there's standing appointments like dialysis that have to happen at certain times, so the employee has to work during certain other times. It's hard really to answer it without context, but in general, an employer has to accommodate an employee up to the point of undue hardship. And undue hardship, it's kind of ethereal. We don't have an exact definition of what that is, but if we dive deep into the case law, then we can tell what it's not. And what it's not is mere inconvenience, right? So if it's inconvenient for you to schedule that shift, then it's not that. If it's just a cost issue, that it's going to be a financial issue, unless it becomes undue financial hardship, like you have to start firing other employees in order to accommodate this employee, then we're not really at undue hardship, right? So if this shift exists, this 8 to 4, and there's a medical need, then potentially you do have to accommodate. But again, without further details, it's hard, and I can't provide specific advice, but in general, that's where we stand.
Okay, excellent. Next question for the offer of employment. And I can see there's a couple questions here. We've got a lot of people that I know that clients are always asking about these offers. When you tell a candidate and you say, I'd like to offer you a position, $100 an hour, for example, if you put the expectation in there to please come back and pick up an employment contract that has to be signed before you start work, is this okay? And a couple other questions along the same line that are, how do you do this and follow it up with a formal employment contract?
Okay.
Sure.
Ljubica,
I can take that. Yeah, it relates directly to that two-step offer case that we were talking about. My suggestion is to have an employment agreement ready before you have really your candidate there, right? Because then once you have your candidate selected, they're going to be offered a position. You are then able to say, this is what I'm offering you, and it includes everything, the good, the bad, and the ugly, right? It includes all of the terms that are protective of the employer, but all of the good stuff for the employee. So then there is no question around, is this a two-step, or was this just the one step extended, right? And as we saw in that case, it was mere days. It was days and really like hours between the time that these two offers were made. And in the end, the employer lost out because there was no additional consideration. So just to err on the side of caution, I would say this sort of method of offering the position and then asking the employee to come in and get a contract, to just scrap that and go with just, here is the offer, here is the employment agreement before you provide anything, right?
Okay. Perfect. Next question, and I have someone saying, I believe it is coming mandatory, and I just lost it here, to provide an offer letter. If we have contracts to sign, do we have to give an offer letter as well? And I think for July 1st, I know we all know what that is. It's coming up in Ontario. I'll let you guys answer that.
Sure. Yeah. I mean, the offer letter is not necessarily, it's not necessary, essential. I think what Ljubica said is the best practice in terms of giving the employee the full, all the wording in the contract as soon as possible, even if it's just so that they can review it in full without necessarily signing it, so that they can never say, oh, this is not the contract I agreed to. So I think that's the best practice in that situation. Excellent.
All right. And then a question here, just to be clear on the terms, is fixed term employment the same as contract, or why are we saying fixed term? What does that mean?
Oh, sure. I can answer that. A fixed term, yeah, it's a great question, because sometimes they're seen as similar things, but an independent contractor agreement is a non-employment agreement entirely. It's a business to business type agreement. It's kind of a contract between a service provider and a client, essentially, like, and that's the way that you're trying to portray it. A fixed term contract is a employment, as we usually refer to it. We say a fixed term contract is an employment contract that says it expires in 1 year or 2 years, etc. So you can have a fixed term independent contractor agreement for sure, but an independent contractor agreement is an agreement that is a non-employment agreement. It's with someone who's a contractor, and that gets into the classification issue we were discussing before, but they're definitely different things for sure.
All right, excellent. And there are a lot of questions coming in about the fixed terms, and what if we're covering a maternity leave? What if we've only got funding for the government for 3 years? What do we do in these situations?
I can feel that, sure.
Yeah, for sure.
Yeah, a lot of times, you know the term, you know when it's supposed to end, so it makes sense for you to ask for a fixed term. So here's the start date, here's the end date. That's the fixed term. But in reality, you are essentially signing yourself up for that entire amount of time. You're contracting with this employee to employ them for that entire amount of time. So even if, let's say, it's a 3-year funding situation, if you find that this employee is no longer suitable for the position and you have to terminate after year 1, then you'll have to spend the rest of that funding on this employee and have no one in that position, because you are, or not 100%, but you might be in the situation where you have to pay out the remainder of the term. And that only happens when you don't have termination provisions in this fixed term contract, or if your termination provisions are invalid for some reason. So let's pretend a Dufault case comes along in 2025 and invalidates your termination provisions in your fixed term contract. And then you're in a position where you have to pay out the remainder of the term. So even in those situations, when you know the start and the end date, we would still recommend an indefinite term contract. Because then even if your termination provisions aren't good for some reason, if they're invalid for some reason, then the common law would still probably give that employee less than what you're giving them, right? Because the common law comes in at around 1 month for every year worked. That amount goes up depending on certain circumstances. So let's say it's a 3-year position, the employee works for 6 months. At common law, they might get 1 month, more or less, in that, 1 to 3 months even. But if you have a fixed term, then you might end up owing that employee 2 additional years, right? Or 2.5 years, which is way past any common law entitlements that employee would have gotten. So I hope that answers it. If there's follow-up questions on that, throw them in the chat.
That's great, thank you. All right, so ramifications. If a manager or executive level leader fails to investigate or take a harassment claim seriously, what can happen there?
Okay. Yeah. In those situations, as Ljubica was telling you, the case law, has sort of given a cautionary note to employers to be more proactive in investigating. The threshold of so-called probable cause or reasonable cause to investigate to trigger an obligation. Now, as we learned today in the case law, is reached a little bit earlier, such that just because an employee doesn't actually come forward and fill out a form or articulate a complaint, and from other sources that there could be a problem, it doesn't absolve you of the responsibility to investigate. Now, what that investigation should entail is a different issue, but the threshold obligation, I believe, to investigate would arise upon there being any knowledge on the part of the executive or someone in senior management. And there's knowledge, and then there's imputed knowledge. There's knowledge that you can deny, but if there's an email or something that shows that you were sent and told something, then it's probably best to err on the side of caution and investigate for sure.
Okay.
I would just add to that, in terms of like specific ramifications, the duty to investigate comes from the Occupational Health and Safety
Hmm.
Act in most provinces. So if you're not investigating when you should have been, then there's potential ramifications in the way of fines, and other punishments um, under that legislation. But there's also the employee can quit and claim constructive dismissal, and say like that environment was poisoned, toxic, etc. You might have to pay termination pay to that employee. So there's a lot that can be fallout from a failure to investigate. There's a lot that can happen, a lot of unintended consequences of not investigating.
Okay, wonderful. Thank you so much for the clarification there. Okay, a bunch of questions have come into people asking about out-of-date contracts or things that could potentially cause a liability. And how do they update those contracts? Would it be seen as a secondary contract? What do they have to do?
Yeah, it's a good question. There's two situations. You're dealing with existing employees and as yet hired brand new employees. So just leaving aside the new ones, and you're dealing just with existing employees. There's not only reviewing their contracts and saying, with a lawyer and taking suggestions, and if the advice is everything's fine, then that's great. But if not, then the other issue that arises, and sometimes the more complex and difficult one, is broaching the subject of changing the contract with the existing employee. And an employer has to be quite careful with that, especially with longer service employees, not only because it can just create friction, unintended friction, questions from the employee, a little defensiveness potentially, but also the legal ramifications as well. The employee, in some instances, could jump the gun on you and claim constructive dismissal, and saying, even though all you did was raise the idea, that somehow you were strong arming. And that's where it's important to keep in mind that judges generally look at the employment relationship as an unequal one, and they start from that standpoint. They assume that the employee is, even if they agree to something, that they didn't do so voluntarily and stuff like that. So you really need to be extra careful in approaching the employee about the changes that you want to make. And in some cases, they will be fine with it. But in a termination clause, for example, we've had some instances where, an employee will get presented with a new clause, brand new, up-to-date 2025 termination clause, take it to their lawyer. The lawyer tells them, heck no, go back to your employer, pound on the table about it. And now you're into a bit of a dialogue. So there's two pieces. There's the drafting and the review, but also just the human element of dealing with someone and their existing contract. But it doesn't mean it's impossible. It just means it takes some care and consideration.
Excellent. And I think we have time for one more question here.
Sure.
What are our legal requirements when dealing with an employee who's called in sick several times? They've used up all of their sick and vacation time for sick leave. What can we do? What can't we do?
Okay, I'll deal with this. We deal with this on a day-to-day basis, as you can imagine. So the first thing I would say is, if you're past the time frame where you can legally not ask for a medical certificate, then the first thing to do is to ask for a medical certificate. And this is just to paper the file, but also if you have any reservation, any qualms, questions about whether or not the employee's entitled to the leave, then you want a medical certificate or a functional abilities form or something to substantiate the need. And then the second is, if you get that and that form, even if it's a vague doctor's note, we see these all the time, employee sick, will not come back for 2 weeks, it's fine. You, as the employer, have to accommodate. Part of that accommodation is letting that employee take the time that they need to recover and then return. So even though under employment standards legislation, maybe they've run out of sick time, or maybe under your own policies, they've run out of paid sick time or something to that effect. Under human rights legislation, you can't terminate this employee just because they are sick. So you have to continue the accommodation process even after that time frame in the ESA has expired. And then what happens after that will really depend on the employee and how things unfold. In some instances, you'll have employees who just come back without accommodation, no issues. And in others, there'll be heavy accommodation for a long period of time in order for them to reintegrate into the workplace. But as we saw in that case, it has to be a two-way street, that accommodation process. And I'm going to stop talking now because it's 3 p.m.
Excellent. No, that's a wonderful answer. And I'm sure there's a lot of people here that have been in that boat or, or just starting to get onto it. All right. Wonderful. Well, thank you so much. This has been a great session. Whether you're a client or not, you're still here. We'd love to connect. If we didn't get back to your questions, I know there's still a lot left on the list. We'd still love to hear them. Email us, service@hrcovered.com. And our next webinar, I'll tell you really quickly about, we've got HR fundamentals for small and medium-sized businesses. It is coming up on May the 5th at 2 o'clock Eastern. That's going to be with Darcy. Thank you so much for coming out, and look forward to seeing you next time.
Thanks, everyone.
Thank you. Have a great day.
Thank you. Thank you, Kim. Goodbye, everyone. Take care.